Ladies and gentlemen, thank you for standing by. Welcome to the Dorsey's Interactive Dialogue Webinar, UK and Continental European M&A of IP-Rich Companies Conference Call. I would now like to turn the conference over to Gina Cornelio, partner in Dorsey and Whitney. Please go ahead, ma'am.
Thank you. Thank you everyone who's joining us today for our interactive dialogue series. Today we are presenting on UK and European M&A of IP-rich companies. We mean for this conference to be interactive, so as you may have questions that come up during the presentation of the slides, please feel free to type those into the chat window in the webinar display. We will attempt to answer your questions as we go through the material. Today is being presented by two of our excellent partners in our London office. My name is Gina Cornelio. I'm a partner in the Denver office with a focus on patent prosecution. And today the main presenters are Fabrizio Carpanini and Alan Farkas. Fabrizio has 30 years of experience in all facets of corporate transactions. As a fluent Italian speaker, he handled many transactions coming out of or dealing with Italian entities. Alan also has extensive experience in all types of M&A transactions, both within continental Europe and cross borders. So I will now turn it over to Fab and Alan to take it from here.
Thanks very much. Hey, thanks very much. Thanks, Gina. Hello, everybody. So we'll just to run through what we're going to be talking about. Before I do that, just to say that we've provided fairly full slides for you. We will try and hit most of the topics that we've mentioned, but apologies because of time constraints if we don't hit every single point. But of course, as Gina said, if you have a question, please ask that. We'll also be taking some questions if we have time at the end. The way that Alan and I have approached this and approached the agenda is to really look at the M&A of IP-rich companies from the point of view of both sellers of those assets and companies and buyers. So the idea is to try and just give you some tips and pointers regarding what you might see, whichever side of the fence you might find yourself from an M&A perspective when dealing with the UK and continental Europe. As far as the agenda specifically is concerned, we will focus on and highlight some of the key differences between acquisitions of IP-rich companies in the US versus the UK and continental Europe. We'll take a look at the style and substance of the sale and purchase agreement. We'll address some of the due diligence issues, including the now often used seller due diligence reports. We'll take a quick look at pricing mechanisms, comparing completion accounts versus lockbox mechanisms. We'll also touch on reps and warranties, the disclosure process, and governing law. So just to start with, let's just take a look at the overall climate that we're faced with at the moment in Europe and specifically in the UK. For those of you that are interested, you will be aware that we're having our own, here in the UK anyway, having our own little challenges with regard to whether we're in or out of Europe. Alan will talk in a little more detail about that in a moment. But funnily enough, certainly that hasn't had a huge impact on the level of transactional activity. It did so immediately after the referendum, but in the last year and a bit, we've seen a very strong transaction climate, helped by, I think, a number of factors, not least certainly when it comes to private equity transactions, the so-called wall of capital, wall of money chasing too few good assets and companies is clearly a factor. I think the fact that that sterling, the pound has devalued as a result of the uncertainty has meant that assets certainly in the UK and indeed the euro opposite the dollar has fallen in value as well. So it's presented US acquirers in particular with some very interesting opportunities at reduced prices to those prices that they were looking at 3 to 5 years ago. So the climate is relatively strong. As far as IP-rich companies are concerned, 2018 saw a number of deals done across different sectors, including healthcare and medical devices, software and consumer and fashion brands. We've listed a few of those deals in the slide. I won't read them out. Let me pass over to Alan now, who will pick up on the latest Brexit developments.
Thanks, Fab. Well, as you've just mentioned, we're facing a few challenges here in the UK and have been over the last couple of months. But notwithstanding all of that, as I say, as the market moves forward, hopefully, notwithstanding the uncertainty around Brexit, life will lead the M&A market to continue to move forward positively for the reasons Fab has mentioned. The reality, however, is that Brexit will happen at 11 o'clock on the 29th of March if, in effect, no other legislation is passed, in effect revoking the Brexit. And to that end, we've moving forward now in quite a strong and aggressive way in terms of UK Parliament, trying to find ways in which they can manage the exit process to the extent that the deal that was agreed and outlined with the EU turns out, in fact, not to be formally approved by the UK Parliament. As I think most of you will know, there has been one particular sticky issue known as the backstop, which is the arrangement of trading between the Republic of Ireland and Northern Ireland. There is an intention to move forward with some amendments to the agreement, and those will be represented to the UK Parliament on the 12th of March or by the 12th of March. But currently, as things currently stand, there is still quite a lot of feeling here now that the UK Parliament will insist upon a deal happening, and to that end, Brexit may be delayed. In a slightly more interesting way, looking specifically at what that may mean, I think that there are, particularly for obviously IP-rich companies, some important pointers in the event of a no-deal Brexit, and that is in particular the impact on IP registration and trademarks. The point, I think, or the important point is to note that anything that has been filed to date, there will be no further impact as a result of the UK leaving the EU. But going forward, after Brexit, there will be the need for trademarks to be filed in both the UK and more generally in the EU, and that is clearly going to be an important move and change. In terms of patents generally, however, Britain will continue to be part of the European Patent Convention, and therefore, to the extent that you've got patents, the same rules and regulations will continue to apply. Moving quickly to the issues, or the principal issues around data transfer. Obviously, the UK is a sophisticated place. We already have huge numbers of safeguards in relation to the export of data, but things will become more tricky post-Brexit, as again, I emphasise in the case of a no-deal Brexit. But hopefully, given the safeguards that are already in place, we shouldn't see too much problems between us and the EU, since it's in both our interests, following the adoption of GDPR, in effect, to try and make things as easily and as smoothly as possible. In terms of personnel, I'm sure that many of you will be aware of the essence and indeed one of the critical reasons why there's been so much talk and the referendum went as it did in relation to the questions of the automatic right to live and work in other EU countries. This will clearly change following Brexit, with the exception of Ireland, where following the Irish agreement several years ago and the adoption of the Common Travel Area, Irish citizens will be able to come and work in the UK, and similarly British citizens will continue to be able to work in the Republic of Ireland. Following Brexit, clearly the rules will change, and then new immigration rules will continue to apply. The intention being that there will be a level playing field, bluntly similar to the approach being taken, for example, with US citizens coming to wish to work in the UK. In terms of taxation, clearly, again, post-Brexit, the current trade agreements and regulations will all fall away, and to that end, new customs arrangements will have to be put in place, and in particular, customs duties. This, I think, is a major focus and will be a major focus over the next couple of weeks, and indeed over the next week to 10 days. The intention is for there to be a major announcement by the UK as to what those customs duties will be in the event of a no-deal Brexit. Moving on, I think, just rather swiftly to the question of enforceability of contracts, something again for the lawyers around the table, which will be critically important. The statements made recently by the UK government are that they do intend to adopt the 2015 Hague Convention, which will simplify enforceability of contracts, provided that those contracts do have exclusive jurisdiction clauses in the contract. And to that end, there will be the ability to enforce the terms of that contract in the relevant country in which that contract was stated of having exclusive jurisdiction, and then similar abilities to recognise those contracts relatively easily in the other EU member states. That's in contrast to situations where you don't have exclusive jurisdictions, i.e. where it's stated to have non-exclusive jurisdiction, in which case it will depend upon the domestic rules in relation to each of those countries. So if you haven't already, and I'm sure most of you will have, if you've got contracts under UK law and or under EU law, I think that it's important to look at the question of exclusivity to see whether or not and how easily those contracts will be enforced going forward.
So, Alan, we have a question. Would that be something, if you're in the process of a deal or acquisition, as a closing deliverable or something of the such, to renegotiate with a party to update the contract provisions for exclusivity?
I would. Thanks. Yes, I would definitely be trying to drive any contract that's currently being negotiated to having exclusivity, since you'll have a much easier approach going forward in relation to the enforceability of that contract, both in the principal country, almost certainly where the deal is being taken, and indeed then subsequently in relation to other jurisdictions that might touch on what is being covered in that contract.
Thank you.
Okay, thanks, Alan. Let me just pick up on transaction structures, documentation, and common practice. Let's start getting into some of the detail, and as I said at the top of the call, giving those of you that are involved in these transactions some tips and pointers. Starting first of all with offer letters, and this won't be anything very different from what those of you that in the States are used to dealing with. Offer letters typically turning into form heads of terms or letters of intent. I think something that we've noticed here and across Europe, and maybe you have found the same in your jurisdictions, but there is a tendency now to go into a huge amount of detail to ensure that before diligence kicks off and detailed negotiations start, that there's a very clear understanding between the parties. And so that's very much a feature, and I think generally a good thing to ensure that everyone's working off the same principles and off the same page. I mean, these letters of intent or heads of terms will contain the usual provisions around identifying the target and pricing, any conditions, and maybe go into some high-level detail on warranties and indemnities that may be required.
One question. To that point, are you seeing a change with companies rather than negotiating directly involving counsel at the offer letter stage more than you used to?
Are you seeing them engage us as lawyers? Yes.
Yes.
Was that the question? Yes. Definitely coming to us sooner than maybe they used to. One point that I wanted to specifically mention, because I think it brings out a stark difference between the UK and actually other European countries, is the concept of subject to contract, which I think certainly from a US and a UK perspective, we all understand what that means. If we title a document heads of terms or LOI as being subject to contract, we know that we're not bound by that. Possibly the heads of terms might have some aspects that are legally binding. Exclusivity is an example, and we'll talk more about that in a minute. But certainly there is a big difference between the UK when it comes to using that term and continental Europe. Generally speaking, because continental Europe is governed by a different a civil code, the practice there is not to use subject to contract, not least because even if you do use it, if you've embodied all of the key terms within an LOI or heads of terms, it very often can still be binding, even though you might write subject to contract. So what we typically do when we're dealing with continental European jurisdictions is ensure that some element of the transaction is either left out of the heads of terms or isn't definitive. So for example, the purchase price might still be slightly vague, and deliberately so, because the parties don't want to lock themselves into something binding. Signing deposits, not typically used in European M&A transactions other than real estate deals. They are occasionally encountered, particularly when you have a non-UK or European buyer, and there's a perceived execution risk. And we've seen it recently in transactions, I have to say, involving Chinese buyers, not least because of the challenges that Chinese buyers sometimes have in getting funds out of China. And so certainly asking for a deposit, and that could actually be at heads of terms or LOI stage, as well as at signing at contract stage. But as I say, it's not the norm. The amount of any signing deposit, well, clearly from a seller perspective, you want it to be something that is material and will hurt the buyer if the buyer then doesn't complete, doesn't close. As a rule of thumb, real estate transactions require 10% of the purchase price, but as I say, it's a point for negotiation deal by deal. Turning to exclusivity arrangements, typically expected and requested on most M&A transactions, not least in an auction sale process. The length of the exclusivity that's granted is driven by the competitiveness of the auction process. The general climate across Europe at the moment continues to favor the seller of assets, as I said before, being chased by a wall of money, and whether that's private equity money or strategic or trade buyers. And so the norm at the moment is very much to have short exclusivity periods, say 4 to 6 weeks. And yes, invariably these periods can and do get extended, but there's very much an intention on the part of sellers and those advising sellers to keep processes very much focused, hence tight timescales. The breach of exclusivity rarely happens, in all honesty, but from a buyer perspective, you want to avoid any breach resulting in a penalty payment, because that wouldn't be enforceable. You need to, as a buyer, link it to your actual loss that you suffer, so the professional fees that you've incurred and therefore lost if the seller breaches exclusivity. Invariably, a seller and its corporate finance advisor and lawyers will want certain offer terms to be reconfirmed as the exclusivity period winds down, and often it's also the case that exclusivity or continuing exclusivity is conditional upon certain milestones being achieved. For example, certain due diligence milestones.
Fab, have you seen those diligence milestones laid out in the offer letters that lay out the exclusivity window, or are they negotiated after signing of the letter?
No, you're right. It's very much part of the heads of terms or the LOI, so it's agreed at the outset when the exclusivity is being granted.
Okay, so having dealt with the specifics in relation to the pre-sale and purchase agreements, just turning then to the sale agreements themselves, whether that be a share sale in the case obviously a corporate sale, or an asset sale in the case of obviously an asset purchase, asset sale. I think that obviously most of the people around the table will have seen US agreements and indeed UK agreements, and will notice the fact that they are, in terms of how they look at least, quite different. However, again, similarly to many of the other aspects that Fab's already talked about, there is a lot of common terminology and indeed common terms between both the UK style and the US style agreements, naturally including issues to do with conditions, price, warranties, indemnities, non-compete covenants in the form of restricted covenants, confidentiality, termination, etc. So as I say, whilst these agreements, when you put them on the table, will look quite different, frankly, they're both covering very much the same commercial terms. In terms of the UK, and in particular where we're dealing with IP agreements, it is quite often the case where you've got IP-rich companies that the buyer may indeed be seeking to structure the agreement around an asset purchase agreement rather than a share sale agreement, the benefit of which is obviously that they can focus specifically on the assets that they particularly want to acquire, namely the IP. Clearly, there's always a contra-argument, which is, well, if you start looking and acquiring the IP through an asset purchase, you may have problems in terms of potential change of control issues to do with licensing, etc., etc. But it is certainly the case that in an IP-rich company, the buyer at least will and may often look to want to create a specific asset purchase agreement for the things that it particularly wants. Equally, the benefit of an asset purchase agreement is that to the extent that you've identified through diligence issues to do with problems of litigation or possibly tax, again, the benefit of the asset purchase is that you're only going to be acquiring the assets that you really do want to acquire. Again, nothing particularly unusual here, or not something which is particular to the UK, but we do see quite a lot of pre-sale reorganisations, again, trying to make sure that we can identify and focus on the crown jewels as we describe them in the UK for those assets that we particularly want to acquire, making sure that they're in the right place, maybe in a bespoke SPV type subsidiary. Again, it helps potentially mitigate tax liabilities on the sale. Also, one can ensure that one's focused on the need for, in some cases, a dual IP license arrangement, say particularly because some IP needs to be carried on by the seller for a period of time, or indeed for a short period of time by the buyer. So moving on to transitional services, again, something which is very prevalent in the M&A market in the UK, recognizing again that there is often a situation where certain assets or certain facilities will need to be shared for a period of time post-closing, the most common being accounting or back office support. Again, IP may be having to be shared for a period of time, and indeed premises as well. When you're looking at transitional services agreement, it is clearly important to make sure that you've really thought through the issues around pricing, exactly what it should cost, and what period of time the TSA should continue for, what circumstances you will want to terminate that agreement, particularly if you're acting for the seller. And then again, just looking at the IP situation, if you do have a license, should there be any dual right of development in relation to either the seller who's carrying on that IP or indeed the buyer that bought that IP. Again, as I mentioned before, one of the often terms in a sale and purchase agreement, maybe less so slightly in an asset purchase, will be the conditions. The typical conditions will be change of control. That may be because there's a regulatory approval required, and that needs to come through before you effectively allow a change of control to happen. As people will be aware, there is two different types of regime in Europe. In the UK, we have the CMA, which deals with antitrust issues up to a certain level. Once you get beyond certain thresholds, currently, whilst we remain in the EU, the CMA will control that, and then above those thresholds, you'll get into EU merger control, which are at much higher levels generally. Obviously, following Brexit, everything will then be and will come within the CMA approval regime, and we're looking currently at potentially how that regime will change and how the thresholds may show a greater flex, but we'll have to see how that moves forward. The third often tax condition, particularly if you're acting for a seller, will be tax clearances. The seller will be very concerned about, particularly if you've got individual sellers, making sure that there is a tax treatment on the sale of a company to ensure you've got capital gains tax treatment because of the difference in tax regime between that. And also making sure that there aren't any anti-avoidance regulations breached as a result of the way in which you've structured that sale. So, as I say, those are the three typical conditions that you often see. Moving forward, the other interesting aspect, I think, is the issues of IP. Again, often as a part of the conditions, you may see the requirement for delivery of an IP license, maybe because that IP is already jointly owned by a third party, and you'll want to make sure that there is an IP license in place or approval given by that third party. You may also find that a critical part of the company is the fact that the IP has been charged to a bank or other financial institution, and again, you'll want to make sure that that IP is free and encumbered at the time of sale. Other issues just to think about in terms of conditions is the timetable that you're given for satisfaction of that condition, making sure that the buyer is particularly satisfied that the condition has indeed been satisfied and not left out there for a future argument between seller and buyer, which I have to say seen on several occasions. And then finally, if you do find yourself not having satisfied the condition by the time set, what is the process for extending the time? Query if the condition isn't satisfied, should there be some means by which expenses are reimbursed? And then alternatively, does the buyer wish to take on that business or that company, irrespective of the fact the condition hasn't been satisfied? Dealing specifically now on the question of due diligence, and how for an IP-rich company there may be some important checks to kind of work through on the due diligence. Work product developed by contractors, essentially that means that we need to make sure, and will make sure as part of a due diligence exercise, that IP has been developed and is owned by the company rather than by the underlying employee. Generally speaking, if you've got the terms and conditions of employment right, any IP that's been developed by an employee will be owned by the company. However, there does tend to be some tension here between the approach taken in the UK and in Europe. But again, the important point here is, as part of the diligence, where you've got an IP-rich company, do make sure that you're comfortable that the IP is owned by the company and hasn't been and is not owned in effect by the employee, and in particular that there isn't a liability due to the employee, which can be the case in some European countries, and you've made sure that that is unencumbered at the time of sale.
Well, and I'll just add in quickly from the patent perspective, we see a lot with inventions and other improvements where startup companies often do not have formal agreements with their employees or have designated everyone as a contractor. And this is a particularly thorny issue that can jump out unexpectedly. So just something to be aware of.
Thanks very much, Gina. And then just very quickly dealing with the registered rights issues. I'm not going to say very much here, just to say that between the patents and the IP and registered trademarks and everything else, it's a very complex system, both in the UK, but more importantly across Europe. And there are different rules and regulations that may apply to your trademarks, to your IP, and those systems may again differ depending upon the European jurisdiction in which you're dealing with the sale.
Okay, thanks, Anne. Let's just turn our attention now to the specific due diligence reports, and as I've mentioned in the first bullet on this slide, the typical reports will center around the usual things like the financials and legal, commercial aspects, and then of course specific areas including IP and insurance and the like. What we've seen, this is why we've specifically landed on this topic. What we've seen over the last 5 to 10 years in the UK and continental Europe is something that I think you are seeing less, but maybe it's creeping into the US market. But it's this emergence of seller diligence reports or vendor due diligence reports, VDD as we term them. These originally were prepared by sellers and their advisors, focused primarily on financials in the past as a way of eliciting a more considered offer from prospective purchasers. But actually now they've become used across different aspects of a deal to include legal and commercial, designed not only to elicit more considered offers, but also to keep an auction process running smoothly and quickly. It's fair to say that they're used in deals over a certain size, so tend not to be used, not least because of the expense risk in deals sub $50 million. But that can vary, and tend to be used where there's clearly going to be competitive pressure amongst various buyers and purchasers. From an IP perspective, I think certainly where you've got the focus all around across the intellectual property that the target holds, then certainly from a seller perspective, ensuring that you have an IP report ready and available, not just to keep the process running smoothly, but actually to flesh out any underlying issues or problems that there may be that you can address pre the process starting is helpful. So these VDD reports, as we term them, probably it was the private equity sponsor that was the main driver for such reports in when selling portfolio companies, but they become now more prevalent, as I've said, across many M&A type transactions of a certain size. I think when we are acting for US buyers, there's understandably a degree of skepticism about these reports for obvious reasons. They're prepared under instruction from the sellers, and therefore, the question is naturally asked, well, what use are they to the buyer? And that in turn leads also to the question about reliance. Can the buyer rely on the reports? So the typical arrangement is that in an auction sale process, these VDD reports are made available to buyers through the data room, and in the first instance, very much on a non-reliance basis. But then once the purchaser has been chosen and invariably granted a period of exclusivity within which to complete the transaction, and the original author of each report will be possibly asked to do some top-up diligence. Maybe the buyer decides that it wants its own advisors to do that top-up diligence. But when it comes to the point of actually signing a sale and purchase contract, it's really important that your legal advisors have negotiated with the sell side's legal advisors what we term reliance letter, so that you as a buyer then get reliance on those reports and ultimately can sue under them if they're wrong. The question of reliance also throws up the question of cost. Certainly in the past, it was common practice to pass on the cost of preparing those reports to the ultimate purchaser. More recently, actually, we've seen sellers and target companies in effect swallowing or absorbing those costs. But it's a question for negotiation. We're going to talk now a little bit about pricing mechanisms and the practice that we've seen developing over on this side of the Atlantic over the last few years. First of all, let's just consider for a moment what the traditional method of finalizing a purchase price for a target company. Many of you will be familiar with the completion accounts mechanism. Some might argue that that mechanism, which in effect draws up a balance sheet and a set of accounts to the date of closing, favors possibly a buyer because it gives a buyer another bite at the cherry in terms of a further price negotiation. Of course, that does sometimes happen, but it also throws up other questions when one uses a completion accounts mechanism, namely how much does the buyer actually pay the seller on closing, and whether or not part of any purchase price should be placed into escrow pending agreement of those completion accounts. And so partly for the reasons I've mentioned regarding uncertainty at completion over what the purchase price will ultimately be, and also a desire on the part of sellers to know what it is that they're going to end up with, we have seen over the last few years an emergence of this so-called lockbox pricing mechanism. And I just wanted to talk about that for a few minutes. So, again, here we might be able to put the blame on the private equity sponsor for being the main proponent of this mechanism, wanting possibly as a seller of its portfolio companies greater certainty on the price it'll ultimately receive to be able to return funds quickly to investors. But in any event, whatever the reason, the mechanism is prevalent now. And I think it's difficult to argue that it isn't a seller-friendly pricing mechanism because unlike completion accounts, it doesn't provide any formal structure within the sale and purchase agreement for calculating and verifying the purchase price post-closing, the price is agreed and fixed and drops into the sale and purchase agreement. So what is the lockbox? The lockbox is a balance sheet drawn up to an agreed lockbox date, which precedes the date of the sale and purchase agreement. The date can be 2 or 3 months pre-signing, or even as long as 6 to 9 months. Sometimes it coincides with a financial year end. Clearly, from a buyer's perspective, the buyer will want the date to be as close to signing as possible. The lockbox mechanism seeks to, in effect, draw the balance sheet as at this pre-signing date. The sale and purchase agreement, the SPA, will contain certain protections for the buyer against the seller having extracted value from the locked box before closing. And so there'll be a series of clauses in the SPA backed by an indemnity in favor of the buyer. But as I say, there's no formal mechanism for adjustment of the price. The seller, in adopting a lockbox mechanism, agrees to pass the economic risk and reward in the business to the purchaser from the lockbox date. However, because the seller doesn't receive the sale proceeds until closing, the seller will often seek a rate of interest on the agreed equity price, or what we call a daily ticker, to represent the lost profit between the lockbox date and completion.
Fab, we have a question on the lockbox. So in the event that something comes up during diligence, if there's a lockbox arrangement, the price is set, and diligence that won't help to kind of reduce the overall purchase price. Is that right?
No, I'm afraid that that's not right. The point is that diligence being done pre-signing will be on the lockbox accounts, and therefore anything that comes up will be factored in to the purchase price, which is then dropped into the sale and purchase agreement.
Understood. Okay, so there's still ways for diligence to affect it. It's just locking in the purchase price that's after diligence.
The important thing is that diligence is undertaken and concluded before the sale and purchase agreement is signed, which would be normal.
Perfect.
So, moving on to that delightful subject, reps and warranties. Again, as we talked about earlier, when we talked about the substance of the sale and purchase agreements in the UK and the US, and the fact that, notwithstanding the fact that the format might look a little bit different, the content is very much the same. I would suggest that, again, dealing with US agreements as I do, as well as UK agreements, there is a very much a similar common approach in both the UK, query Europe, as well as the US when it comes to the scope of the form of these warranties. You would expect to see typically ownership of assets, compliance with laws, litigation, comfort around employees, intellectual property, maybe real estate, and just generally speaking, the same subject matters. I think, again, probably similar as in the US. The difference is when it comes to public deals, i.e. companies listed on some form of exchange, and indeed when it comes to private equity, in those circumstances, the scope of warranties will be much limited, if indeed limited specifically just to the question of ownership of your shares. And what you'll then be doing in the case of public deals and PE will be very much more reliance on due diligence and the inclusion of the VDD reports that Fab mentioned a little earlier. When it comes to the approach to warranties, and again similar I think to the US approach, there will be a strong reluctance by a seller to move to any form of representation rather than a pure warranty. The warranty be based around contractual liabilities as compared to representations, which in the UK are talked about in terms of tortious liability, which is a much wider, all-encompassing liability issue. The issues around the sale and purchase agreement and the protections for sellers, again, you'll expect to see, I think, similar to the US, some form of time limit on the duration of the warranties. I have to say, I think that the difference between the UK and the US is that in the UK, warranties, generally speaking, can continue for a much longer period than at least I've seen in many cases in the US, where warranties may in fact fall away certainly within 12 months and possibly even sooner. In the UK, I think it's pretty unusual to see warranties falling away in less than a year, and much often there'll be a 2-year period, albeit that within that there may be warranties or fundamental warranties that have a shorter period, and then a wider set of warranties, maybe less important warranties, but warranties that are more difficult to discover, having a longer period of time. Similarly, you'll see thresholds, namely a threshold liability cap, and then also an amount which may be a throwaway amount that the buyer will have to take on board, otherwise known as a de minimis, before the seller is responsible. And then the important aspect, again, which we'll be talking about in a moment, will be the issues around disclosure. And again, within that, the issues around VDD reports, but generally speaking, how much disclosure has been made to the buyer, what's the nature of that disclosure, how much diligence has been carried out by the buyer in the period prior to signing, and all of that will be reflected in the form of liabilities for the seller. Probably, I guess, the issue that I have to spend most time when I talk to a US buyer is trying to explain the different approach between what we call here damages arising from breaches of warranty, as regards the more typical approach, which is that if there is a breach of warranty in the US under a US style agreement, you'll simply have an indemnity, namely you'll be covered for the loss on a dollar for dollar or pound for pound basis, whereas in the UK, unless you've identified a specific liability prior to signing, which is then reflected in the sale and purchase agreement, when you're acting for a seller at least, you'll be really insistent that any loss that is subsequently discovered as a result of a breach of warranty will be based around damages. And therefore, the onus will be upon the purchaser to show not only has there been a breach, but in essence, what the type of loss is and how you can quantify that loss, which can be much more difficult when you're dealing with a question of damages, as obviously compared to a question of indemnity, which is, well, you simply say, well, that liability, is for £100,000, and therefore that's the indemnity, and that's what we intend to recover from you. Whereas if there's a breach of warranty based around damages, it's got to be about, well, actually, what was the company worth, or what did you think the company was worth at the time of sale, as compared to what is it now worth, after the breach has occurred. So, as I say, a very important, I think, difference in approach, and one which is still very much resisted when it comes to indemnities, just generally for breaches of warranty in the UK context, as compared to what's normal and typical in the US.
Let's spend a few moments talking about the emergence of what we would term warranty and indemnity insurance, and what our US colleagues would term rep and warranty insurance. Broadly speaking, very similar products used on either side of the Atlantic, but with some subtle differences, not least touching on some of the points that Alan's just been talking about. And that's why it's really important. We were recently advising a European target opposite a West Coast acquirer from Seattle that understood that the private equity seller, in our case, was not going to provide much in the way of warranty cover, and therefore ran off to its broker in the US to start talking about putting in place a rep and warranty insurance policy, but a lot of time was wasted because the policy needed to actually address UK and actually broader European issues. So any buyers out there that are in similar positions, our advice is very much to deal and treat with insurance brokers that are based here in Europe, to ensure that you have exactly the right type of product that would meet a European style transaction. The private equity position is also just worth noting, the private equity seller position, because I think that's another difference between Europe and the US. As I say, typically here, you will not get anything in the way of meaningful warranties or indemnities from a private equity sponsor seller. That seller will only tell you that they own the shares and that they have capacity to transact. They won't give you any business warranties. So often in that situation, there is quite a fundamental gap in terms of the price being paid and the warranty cover available, hence the use of this product. A few years back, it was typical for a seller, when interested in using this type of product, to go into the market and insure its own liability, so that if a claim came into the seller could then offload that liability to an underwriter. But that type of product less used now, and we now see what's termed purchaser policy being much more frequently used. It's a policy that is sometimes in an auction sale instigated by a seller and its advisors, but then as warranties become settled, as negotiations progress, the seller and its advisors will literally hand over the negotiation and implementation of that policy to the buy side, and then the buyers deal with the underwriter through their chosen broker to finalize the terms of the policy so that it's implemented and completed to coincide with the sale and purchase agreement being signed. But what that does is it means that the buyer has a direct relationship with the underwriter, and if there is a warranty claim, can go directly to the underwriter and doesn't have to pass through by making a claim to the seller first. So it makes life a little bit easier. The scope of these policies can obviously vary from deal to deal. In an IP-rich target business, whilst the general policies are helpful, it's often the case that we see that we've got to go and for sellers that have title issues in relation to their IPRs, they have to go into the market and buy specific or find specific IP-related policies. But all of these are available. I mean, just this afternoon, I've been dealing with a broker on a specific tax policy to cover a potential tax liability. The market has become much more sophisticated. There's a prevalence of underwriters in the market. That competition has led to a positive impact on pricing. And as I mentioned in the notes, as a rule of thumb, certainly for a standard warranty and indemnity insurance, you'd be looking at a premium in the range of between 1% and 3% of the required coverage. Turning now lastly to the disclosure process itself, to highlight a further difference between the US and European practice. Certainly in the UK, maybe less so in continental Europe, it's very much the tradition to have a separate document listing out matters that contradict warranties, those warranties that appear in the sale and purchase agreement. This document we call the disclosure letter. I think from a US perspective, it's more normal to see those disclosures actually built into the sale and purchase agreement, either by way of schedules or within the warranties themselves. So this disclosure letter has two aspects to it. First, the disclosure letter has general disclosures, things that a buyer is deemed to be aware of, so information that it could glean from a search of various intellectual property registries and other registries, the buyer is told, you have to go and do those searches as part of your diligence, and you are fixed with whatever knowledge you glean from those registries. Separately, there are specific disclosures, and they are exactly that. They are specific to certain problems or issues that contradict the warranties that are being sought. The final point for me to make is the what we would say the age-old question of whether or not wholesale disclosure is permitted of the contents of data rooms. Always a hot topic, which keeps us lawyers awake at night. Certainly, from current practice, it seems to be that notwithstanding the fact that it is generally a seller's market, wholesale disclosure of the data room, which was possible and a relatively easy win a few years back, is now certainly not the norm. And I know that US buyers are very strong on this point in resisting it. And I'm pleased to say, from a buyer perspective anyway, that that argument now is frequently being won for buyers, and wholesale disclosure is not acceptable, and there's an insistence on specific disclosure. So that brings us to the end of what we wanted to discuss. I don't know, Gina, if you have any other questions.
We'll give just a moment if anyone has any last questions they would like to submit via the chat box. Please do so now, and we can relay them. Otherwise, we look forward to hearing from you. Here's the information for CLE, and please reach out to Michelle. She'll send you the certificate. And let us know in the survey at the end of this, once you sign out to the webinar, if there's any additional topics that you may be of interest of, and we can include those in our next presentation, which will be in a few months. Well, it looks like we don't have any new additional questions, so I'd like to thank both Fab and Alan for their time today to go through all of this information, and please do reach out to either Fab or Alan directly if you have any specific questions. Well, thank you all, and we look forward to hearing from you.
Ladies and gentlemen, that does conclude the conference call for today. We thank you for your participation and ask that you please disconnect your lines. Have a great day.